The topic that we are going to discuss today is copyright. Copyright, and in the process, we will try to see what is copyright and how does it matter to uh, the use and the dissemination of information, or how does it applies to the library services. So, anybody who is dealing with the management and distribution of books, articles, and contents produced by others should know what is the copyright issues. Okay, that it doesn't matter you're dealing with, you're a librarian or you're someone else dealing with audio visuals. Okay, so in fact, it is very important that everybody knows a little bit about copyright issue. Then this copyright can be much more effective. So what can you do? The question is that what can you do with the content you're dealing with? Who is it? Who is the owner? These are some of the things which is very important to know and to understand. So we will look at the basics of copyrights. I mean, starting from the source itself. Then we'll see whether what is a bond between the authorship that exists between the author and the work he or she wrote. And then we'll also try to see what are the legal frameworks which is available that comes with the copyright. Now, first, let us try to understand authorship. Say, for example, a carpenter is making a wooden box uh, with the wooden planks. He bought it. Okay, he bought wooden planks, and then he made wooden box. Now, in most culture or in most countries, the carpenter is the owner of that the wooden box that he or she made until unless he or she decides to sell it. Okay, so the ownership come from the carpenter's own work, the time he or she spent on cutting, shaping the wood, putting them together, designing and fastening and all of those things. So that makes the carpenter the owner. Now there is no problem with this kind of tangible objects, because objects such as this, physical objects is very easy to assign and understand. And yes, the carpenter or this person owns the object. Now, the problem comes when something abstract like songs, poems, stories, or that when this kind of thing comes, it becomes a little bit problematic. Why? Because most of the time, these are not produced in tangible objects, not like a wooden box, not like a wooden, physical object that which can be owned or which can be given away to someone else. So this becomes something more abstract. Okay, abstract. So that is where people get confused as to who owns that particular thing. Okay, am I dealing with, suppose if I'm singing with someone's song, then they since it is not physical object, a song is not a physical object, so people started thinking, taking it that I can do whatever I want with that particular song. Okay, so the concept of ownership or authorship is usually confused or misunderstood when it comes to such type of works. However, the composer of a new song or somebody who have just come up with a new story should be recognized. I mean, they have a special bond as a creator of that particular work, whether it is abstract or physical. So, so there is a bone. So that bone is what we call it bone of authorship. Okay. So if I write a new poem, I am the author. If you write a new song, you are the author. Okay. So copyright is about recognizing that this bond between the author and the work they created. That is what we call it copyright. It is a legal recognition of such bond. Okay. Now, copyright doesn't is not applicable in everything. There are certain areas which other kind of laws are applicable. Okay, so other kinds of intellectual property rights are applicable. So when it comes to copyright, the law this copyright law is applicable in creative works like literary works like books, articles, etc., musical works, and then artistic works like drawings, pictures, maps, diagrams. Okay, so it is applicable in the intangible work rather than in any particular embodiment. This is again an argument that copyright is, I mean, in the creation, in the work, not in the embodiment or the place where it is being, the medium through which it is being transmitted. Now, copyright experts like to say that copyright subsists and work because copyright has no separate existence without it. There are two conditions to have a copyright, that is originality and creativity. The first thing is that originality means that author A, okay, a person, this A has written a song, for example, and then this song is copied by, so Mr. A has written a song, Mr. B simply copies this song, okay, from A. So B cannot claim to be the author because it is simply a copy of Mr. A's work. A is a correct author. So there has to be A has produced something original. B is simply making a copy. So that is there, copyright is not applicable. Then there has to be some level of creativity as well. Okay, let us look at the creativity aspect. Now, as far as the, artist, literary or artistic works are concerned, creativity is not a big issue because the merit and demerit, or the quality, the level of creativity, whether it's good or bad, is not an issue. If I write a song which is very bad, very a very bad song, not of the of good quality, people don't like it, even then I still have the copyright. So in that situation, there is no problem. But there are certain areas in which copyright is an issue. For example, a telephone directory. Whether somebody made a telephone directory, whether that person who made a telephone directory should have the copyright to the telephone directory. Interestingly, the Supreme Court of the United States, way back in 1989, ruled that things like telephone directory, simply a list of name, uh, could not be, is not good enough or doesn't have the merit to be copyrighted. Okay, so it's simply a list, so that cannot be, that cannot come under a copyright. But that is only in United States. So it varies from country to country. In some country, there's no such things as whether there is, good enough to be a copyrighted or not good enough to be a copyrighted. So it is important that we see what is applicable in our country. Now there is whether the copyright should be applicable, as we said in the beginning, should be applicable at the time of composition or at the time of thinking, or should it be copyright should be applicable only after it is recorded, written down, published. Okay, so this is also another issue. Say for example, like a song is an intangible work. It is an intangible work. But when the song is recorded in a CD or a tape, or it is written down in a song sheet, it becomes a tangible embodiment. Now, a book that author is writing, probably typing or whatever, is considered to be intangible work. But once the book is published and made available to the users, it becomes tangible embodiment. An article of a paper is usually considered to be intangible, but once it is published in a journal, okay, open or commercial, it becomes a tangible embodiment. So this is why we put these two things separately, is that in some countries copyright is applicable only when it is fixated. Okay, that means it is only when it is kept or fixed in a tangible form. Only when it is in the tangible form, then copyright is applicable in some countries. Whereas, yeah, in countries like United States, United Kingdom, they require that fixation in a tangible embodiment is required to have a copyright. For example, a speech delivered in a lecture hall is not, yeah, copyright is not applicable there. Copyright is not applicable in a choreography, okay, a dance which is performed. But these two things can be, copyright can be made applicable only when they are recorded, okay. But in other countries like Germany, uh, those works will be protected even without being recorded or written down. So that is nation to nation difference with the requirement of fixation. Okay. Suppose now let us discuss more on something on intangibility. That means inseparability. Suppose a musicologist is recording traditional song, folk singer, the song which is sung by a folk singer. Now, then what happened? Whether the copyright in the song belongs to the composer, whoever he or she may be, or whether the singer, okay, who has a bond with the performance of the song, or whether, should the musicologist who make a recording, should he or she also have some share in the copyright? You know, so this is something which is interesting in terms of music, because the composer no doubt is the copyright owner, but the person who sing also, okay, certain songs, if a person sings this, then artist sings, and then another artist also, the second artist also sings, third also sings. Out of this, probably one of them, okay, maybe A is not that good, two also, A1 is not good, artist two is also not good, but artist three is widely accepted because there is some artistic skill required in the performance of the song. Therefore, the singer also, the person who sings or perform also have some bone in that, some rights in that work. Then when it comes to recording, the way we record, music, or the way we record audio visuals, for example, we use different technology these days. A lot of complex technologies are being used. So simply recording may not make the the work sound good. It requires a skill of the person who records. If the person is highly skilled, has artistic, skill, understanding of the music, then the quality of the music is likely to be much acceptable and much better. So that is why we said that the performance or the sound recording is not the same work as the as a song. Rights of the performance should also be there should be some recognition should be there. Okay, so this uh, is not copyright, but it is something else. They call it neighboring rights. Okay, so it is called neighboring rights. So this term is closely allied to copyright, neighboring rights. The terms like related rights to copyright or just related rights are also being used. So where is this neighboring rights applicable? Neighboring rights is applicable in performance, in sound recording, in broadcasting, in databases, in catalogs, in films, in industrial designs. This is where neighboring rights are applicable. It is not exactly copyright because the copyright still belongs to the author. Now the free exchange, okay, free exchange of ideas and knowledge is very important to the development of humanity. Without the free exchange of ideas and knowledge, human beings will never progress as much as we progress today in a free environment. So copyright should not protect ideas. Okay, that means that copyright should not protect the way ideas are expressed. That is, the language used by the author. Uh, but copyright should be, should allow, should offer propagation of, allows to, should promote the propagation of ideas. Now, in the progress, the process of propagating ideas, for example, conveying uh, abstract ideas, okay, for example, like a complex scientific theory to make people understand, hard to understand things, okay, something which is very difficult to explain, to make people understand those kind of difficult things which without explanation that people will not otherwise understand, requires a great skill. Okay, so a great skill and ability to express the ideas. One person's explanation and the other person explanation is not always the same. They always have some degree of difference. A person may make it sound very easy, the other person may not be able to do that. So the skill of the author actually help the spread of ideas. I may be talking about someone's idea, okay, I may be talking about someone's book, but if I am skillful in my expression or my communication of the ideas, then I help in the free spread of the further spread of those ideas. Okay. So far, we have talked about authorship and about copyright subsists in creative works. Now, what does the author get? The author get as a result of that recognition. We said that the author has a right to, uh, the author has a copyright. Okay, so by owning the copyright, what does the author actually get out of this? Okay, so the owner of the copyright have the exclusive right. Okay, have the exclusive right to do what? To authorize, or to do or to authorize others to do certain things which is applicable within the copyright. When it has the right to, or give the right to others to certain rights, which is sometimes called a bundle of rights. Okay, so the bundle of rights again differs from country to country. Now, what are these bundle of rights? Bundle of rights include the reproduction right, distribution right, public lending rights, and some other rights as well. So out of this bundle of rights, the one which is commercially most significant is probably the reproduction right. Okay, of all the exclusive rights that the owner of the copyright has. So the owner of the copyright has exclusive right to copy in whole or part, okay, in some part or in or the whole thing. If the copyright, work is published commercially, the usual procedure for author is there are two things. If it has to be published commercially, the author may sell the entire copyright to a publisher, or to grant a publisher an exclusive license. Okay, there are two things that the copyright owner can sell their copyright to the publisher, or they can grant the publisher an exclusive license to publish. Okay, so there are two scenarios there, because copying means that much more than simply photocopying. So copying, the reproduction right again covers many of the different techniques for reproducing materials, from handwriting to digital scanning, include, and other that commercial production are also included in the reproduction right. So usually the distribution right is much more limited than the reproduction right. The distribution right in respect of physical copies give the copyright or the owner to decide whether or not to distribute the copy of work to the public. Okay, so but once the copy has been distributed, usually the copyright owner has no control over the subsequent distribution. This means that if I buy a book, okay, then whether I sell it to someone in a reduced rate, or whether I simply give it free of cost to someone else or donate to the library, there the copyright owner has no control. Okay, so that is why it said usually the subsequent distribution, the successive distribution, is outside the control of the copyright holder. That is why the second, this sale of second-hand books normally doesn't require the consent of the rights owner, but then that again, that is a debatable issue. Uh, so that is why the distribution right is said to be exhausted, because it is no longer within the control of the author or the copyright owner. Theoretically, the distribution right can be exercised within national territory. For example, in a country, once it is exhausted, the distribution right is exhausted within that country only. But once it goes across the border, then distribution right is again active. It's not exhausted again. But there are some exceptions, like trading blocks, like this ECOWAS, EU, NAFTA. They are, blocks, formed by multinational, trading blocks. So usually what they consider is that if a distribution right is given in that trading block, then it will be exhaust within that trading block only. Okay. So for example, it is within EU, irrespective of which country, so it will be applicable within that EU only. Now, libraries perform an important role in making contents available to people, so who might otherwise be able to afford it. Now, however, library lends a book, the borrower then, there is some claim by the copyright holder, particularly of the publisher, whose interest is more or less about the commercial interest only. So they said, they have the argument that when a person borrows a book from the library, so there is the person's incentive, or the person's willingness to purchase the book is not there anymore, because they get it free of cost from the library. So in this process, that the library, the copyright holders may lose because of library lending. But again, this concept differs from country to country. Many jurisdictions, many countries introduce a public lending right which compensate the author. Okay, that to make the to get something out of the public lending, authors there are mechanisms in place. For example, like a European Union, public lending right is part of the copyright. Now, in some countries that there are not-for-profit or educational sector, this lending to member of public, is not applicable. For example, in our country, there is no compensation to the copyright owner, whether it is in the library or in some non-profit for educational purpose. Okay, in these two things, there is no compensation to the author. In fact, the libraries publishers are mandated to give, library discount when they sell books to the library. So that is what is applicable in our country. Now, copyright owners have also other rights. For example, he or she have the right to refuse to perform the work, performance of the work in public, can refuse broadcasting of the work. So they also have the copyright owner also has a right to permit or refuse adaptation of their work. For example, making a film out of a fiction. Okay, the owner of that particular story or the fiction, the writer or the copyright holder can refuse that my book will not be made into film, or if it is going to be made into film, I should be given this much royalty. Okay, that kind of the rights are there with the copyright holders. As we have seen that, when it comes to ownership and administration, the first owner of the copyright is basically the author. Now, let us go to a scenario where the author is not working independently. That means the author is a salaried journalist or employee who is employed to write those things. Okay, then whatever he or she wrote during that time of employment, whether that belongs to the writer, the author, or to the employer, that is a big question. Okay, who should own that article? For example, a journalist is paid to write articles. So whether that journalist will owe is the copyright owner, or whether the the newspaper in which or the news agency in which he or she is employed is the owner. This is a big question. Okay. Now, many copyright works are created in the course of employment, sometimes such as work made for hire. So, is there still a bond between the employee and the work, even if they are employed to write those articles? Then, what does the employer get in return for the money they pay to the employee or the journalist to write those articles? So in some countries, there are two variations. The author is an employee, and if the author is an employee and creating work is part of his or her job, then what happens is that the employer owns the copyright. That is, if the author is an employee and creating work is part of his or her job, then the employee owns the copyright. In some other countries, and what happened is that the employer has full rights to the economic value. There is the difference. Okay, the full rights to the economic value of work created in the course of employment, but the copyright itself remains with the author. Right. So the slight difference is there. In the first one, the employer owns everything because the employee is paid to write those work, so the employer owns it. And the second scenario, the economic value, the commercial value is owned by the employer, but other rights, the copyright owner is still the author. So what happened is that many authors, professional authors, employ agents to administer their copyright. Especially those who keep on writing, they have their own agents who are expert in dealing with this type of situations. Now, authors are good at writing, and then publishers also have some contribution. We should not completely push aside publishers. Publishers also have the skill and capital to promote the works to the reader. So they usually acquire interest in the author's copyright in exchange for the investment in the work the author produced. So the legal nature of the publisher's interest in the author's copyright varies from jurisdiction to jurisdiction. So it is also different from sector to sector how a publisher would like to have the copyright. Deal with the copyright. Usually, publishing house have their own section which deals with copyright, who are expert. They have employees who are expert in dealing with the copyright. So when it comes to the author and the publisher, usually the publisher have the upper hand because they have fully a different section who day in and day out are dealing with the copyright issue. Now, if we look at the international legal framework for a copyright, it is important to bear in mind that copyright law is national law. Okay, though countries will have things in common, but copyright, let us always remember that copyright is applicable within the nation only. Now, in order to come up with this copyright, there are so many treaties, okay, where although copyright has our national laws, most nations, take it from the international treaties which started to set out a basic framework for copyright. For example, one of the most important treaty is the Berne Convention way back in 1886. This is considered to be the principal international treaty. And then we have the World Intellectual Property Organization in 1996, WIPO Copyright Treaty, which address issues that is arising because of the modern digital technology and network. Okay, so let us see what are those copyright treaties. The Berne Convention, as we said way back in 1886, among other things. That means there are so many other things that the Berne Convention comes up with, but some of the most important thing is one is a national treatment, that copyright should be within the legal jurisdiction of a nation. Okay, then subsequent a subsistence of copyright without formality, that is without registration. They also come up with this idea that there should not be any formal registration. Okay, then they also come up with minimum term of life plus 50 years. That means copyright should be applicable even after the death of the author. Now, the Universal Copyright Convention of 1952 is another important event administered by UNESCO. This equally provides, this also again affirms national treatment and also allows registration formalities. Okay, so in the Berne Convention, without formal registration, but in this 1952, it allows registration formalities that nations may insist that registration should be allowed. Should be done before the copyright can be applicable. Then we have the WIPO Copyright Treaty in 1996. It adds a number of provisions to reflect changing technology, because by this time digital technology is become widespread. We have digital books, digital articles, and so on. So this convention, it is necessary to recognize that these digital materials should also be brought into the framework of copyright. Okay, so this was, though it is way back in 1996, many nations do not incorporate in their national law. For example, in the UK, it became effective only in 31st October 2003. See the gap. Now, the Rome Convention is also another important event where national treatment and minimum term for neighboring rights in phonogram is being introduced. So subsequently, we have WIPO Performance and Phonograms Treaty. Then we also have TRIPS Agreement and so on. These are some of the important treaties concerning copyright that has shaped the framework of the copyright, which ultimately is adopted by different nations. Now let us come back to the national treatment. The national, as we have said, that international treaties oblige countries to give national treatment to the work by nationals of other countries. For example, I'll give you a simple story. There was a time when the United Kingdom, books written in United Kingdom, when it is sold in United States do not protect works which is published in United Kingdom. So in United States, what they do is that you can violate the copyright law, or you can make copies after copies without the consent of the author or the copyright owner in the United Kingdom. So they can do what they can even change the name of the author, but then this will not be admissible as offense in the court or in the legal institution of the United States. So such was the cases. Okay, so that is why these successive conventions have said that every country should adopt a copyright, should have a copyright, and the treaties provide a legal framework that should be adopted. Okay, so what happened is that this book, which is published in United Kingdom, will be treated like exactly like the books which are published in USA. Okay, in USA, so the books may be published in UK, but when it is exported to USA, it should be treated like books published in the United States. So that is the provision, that national treatment, what we are talking about, national treatment. Okay, so similarly, the books which is published in United States, though it may have different law, okay, that law is not applicable when it is published, I mean when it is sold in the United Kingdom. So copyright infringement or violation of copyright will be treated as per the law of the United Kingdom, though the book is published in United States. So this is what we call national treatment. So that is why, what is important here is that because of all these things, all librarian needs to know is the particular copyright law of the country in which he or she works. So in India, all we need to know the copyright laws of India. Then every book, irrespective of from where it is being imported, it will be treated as per Indian law. That is what we call national treatment. Then coming to minimum treatment. The Berne Convention, as we mentioned, that provides a minimum term of copyright, that is the life of the author. The minimum term is that the author, during the author's lifetime plus 50 years. This is suggested by the Berne Convention. That means that even after the author died, you still need the permission from the whoever inherits the person, I mean the author's property, or who is a heir to the author, to take permission from them. Okay, that is after 50 years of the author died. So you have to take from probably the family member, okay, whoever owns the author's, I mean whoever inherits the author's property. So if a country has ratified the Berne Convention, so the term is at least, okay, minimum life plus 50 years. This is sometimes written as 50 years PMA. In Latin, PMA means post mortem auctoris, meaning after the death of the author, 50 years after the death of the author. Okay, so it is very difficult, sometimes to find out when did the author die. That is another issue. Some national laws provide for a stronger protection that exists under the Berne Convention. For example, in United States and the European Union, the term of copyright is 70 years from after the death of the author. Okay, till that time it is applicable. But in our country, in India, it is 60 years from the death of the author. Okay, 70. I mean, it is in between. The Berne Convention say 50. Some country go to the extent of 70. When we say it should be 60 years from the death of the author. The Berne Convention requires that copyright should subsist without formality, that is, without registration with the authority or legal deposits with the National Library. But some countries, such as the United States, maintain that registration should be a must, so that it, in fact, in our country, for example, in India, we can register it or we cannot register. We may not register it also, but still copyright is protected. We still have the copyright protection. But in terms of legal problem, suppose somebody infringes a copyright or somebody violates a copyright, then it is easier for the copyright holder when the work is properly registered. Then it is much easier. If there is a legal problem, it's much easier to deal with it. Okay, so that is why if you foresee that the work that you do is going to be problematic, is going to invite legal problems in future, it's better that even though it is not mandatory, that we register it. Okay, so different countries and again different thing. Copyright starts by giving authors and copyright holders great power in the form of exclusive rights that we have already discussed. Now this power has to be exercised responsibly. Okay, when we only look at the copyright, I mean the right of the author, the right of the copyright holder, or when we only look at the commercial interest only, then what happens is that we may end up, which the uh, great British just called the progress of the arts. Okay, then we may hamper the expression of ideas. We may become the stumbling block of the spread of human knowledge. So therefore, there are numbers of limitations and exceptions to these exclusive rights, so that the copyright holder or those with commercial interest will not take full advantage and stop the idea being spread. Now, one of the limitations and exceptions is quotation. So the Berne Convention provides that it is always acceptable to make limited quotation from protected work, provided it is acknowledged, okay, then it is done fairly. Of course, most authors would like to be quoted. I would like to be quoted as much as possible. That way I know that the idea which I express is being further disseminated and shared. Or it is also a measure of how important is the idea that I convey. Okay, so that is what the thing. But in some very few and minor copyright holders might object to such type of fair practice of fair quotation. There are other exceptions. Many countries provide for certain other exceptions to copyright. The Berne Convention allows country to enact exceptions subject to particular conditions and generally to make exceptions for special cases, so long as that provides exception does not conflict with the normal exploitation of the work nor reasonably prejudice a legitimate interest of the author. Okay, the use of the work should not be hampered. Exceptions can be created as long as the use or the use of the work is not hampered and the interest of the author or the copyright holder is not compromised. Then there is a concept called fair use in the United States. Fair use is what? Fair use is actually a mechanism to defend for, suppose if a copyright holder says that my copyright is infringed by so and so, so that so and so can use fair use argument that they are using fairly, okay, that they have not infringed any copyright. So it is a defense mechanism when there is fair use. So usually fair use and fair deal, which is more or less of a British term, are usually used simultaneously. It is slightly different in between the two. Now there is also a term called private use. This is in Germany and some other countries also. As long as you are using for your private purpose, suppose you are making copies for your private use only, then copyright you are not you may not pay the copyright holder. Okay, private use of copyright work is permitted provided that equitable remuneration is paid to the copyright holder. Now, one application of the copyright law relate to the, for example, home taping and recording. What they do is that they put some kind of levy on the recording, the tape, for example, used to record there itself, and then the author is, some third-party institution further transfer the thing, the money which is collected through the buying of the tape to the author or the copyright holder. Then we have the fair dealing exists in United Kingdom and including the Commonwealth nations have mostly used fair dealing. Is usually restrictive than fair use. It is much more restrictive. But the two concepts, as I said, fair dealing and fair use should not be used simultaneously. Now, there are library provisions. Many countries have a special exceptions and limitation for the benefit of the library, recognizing the importance of library to the spread of knowledge. So these exemptions, which we will not cover in detail here, but it should be noted that a few exceptions and limitation copyright laws are clear cut. It is not always clear where the fair dealing or the fair use end and where the copyright infringement begins. So usually it is a bit difficult to understand where does copyright infringement begins or stops and where does the fair use begins. So sometimes it amounts to interpretation of the national law. Now, there are some technical measures and right management. For example, like in the WIPO Convention, the WIPO Copyright Treaty introduced, I mean, uh, a legal measure against the circumvention of technical protection measures like digital right management system. Okay, the works, which in electronic forms have the information, probably a metadata information that cannot be tampered. Okay, for example, I think many people might have experienced that in MP3 player, for example, any MP3, decent MP3 player, you can change the information, the artist, the composer, the album, this information can be changed. But as part of this WIPO's treaty, that is supposed to be illegal if you are changing information and giving credit to people who should not have it. Okay. So the first national law to implement this requirement was the United States Digital Millennium Copyright Act. Okay. So this is in relation to electronic objects, how much it can how should they be treated and how they should be administered or managed. Now this is also again a very controversial issue, but sometimes uh, the copyright holders, in most cases the publishers, take undue advantage of this and then put particularly public institutions or education institutions like library in undue disadvantage, okay, to the extent that they are unable to lend their holdings. Now libraries, however, exist to provide information people cannot otherwise afford to buy. If a technical protection measure means that library must pay, for in some cases, this is important. In some cases, a publisher insists that library must pay an additional fee to the right holders. Okay, each time a digital edition is used by a new library patron. So what it means is that we have a digital copy. Library have purchased this digital copy. Now every time library, okay, let's say library has these many users. So every time library adds a new user, okay, they have to pay for additional charge. For example, they have paid this for let us say 30 rupees. Now they have added two more person in the library, so it will be 30 plus they have to add more, then it becomes 50. Okay, so in some cases what happened is that how many times they can be used. Say they said that the document, the digital object is worth, let us say 50 rupees to have the access license. Okay, let us say 500, which is very less. Now 500 rupees. Now for the first 10 use, okay, this has been used 10 times. Okay, 10 times it has been used, and since it is used 10 times, it's free. So from the 11th onwards, they will be charging, for example, 10% extra. 10% will become how much? 10% of 500 will be charged. If they exceed, they use more than 10 times. Such type of things are very silly. But this is how what this digital rights management, the Berne Convention, that's why you say it's controversial, treaties have brought it. Okay. So if such is the case, and there is the library being used, instead of people getting it from the library, it's better, every additional usage, if they have to pay, then it's better than they buy it by themselves. So individually they have to purchase themselves. So these kind of issues are there, and it's still till today it remains unresolved. Let us see in the future what happens. how these things move. That is why, because of these kind of silly restrictions on the part of the publishers or the copyright holders, uh, many authors are moving towards the open access movement. Okay. Okay, when it comes to right management information, okay, we mentioned that a little bit. That removal of right management information is less controversial. Right management information does not prevent the usage. Digital right management, okay, actually only identifies a copyright holder, but it does not prevent. This, the model that we are talking about is the subscription model or the license model, which is practiced by the publishers. Now let us come to moral rights. It is a requirement of the Berne Convention to recognize certain moral rights of the author. So moral rights are inalienable. That means moral rights cannot be transferred. Of course, in some cases, in some countries like United States, United Kingdom, it can be waived. That moral rights can be removed. Now, the economic rights, particularly the reproduction right of some authors, make a living for the writing. Moral rights do nothing. Moral rights do not give any, does not have any commercial benefit. So, moral right is simply the right to acknowledge the authorship, okay, and to maintain the integrity of the work. Okay. Now, let us see further. Now, imagine that if you are not acknowledging the author. For example, I use this material, okay, I took this material from IMARC group, okay, UNESCO, FAO, IMARC group. And then if I don't acknowledge that I've taken from them, then it's like I'm being dishonest. I cannot claim that this is my own work. Similarly, if you copy an idea, if you extract an idea from an author or a paragraph from an author, you copied it, lift it from there, then the author should be acknowledged. That comes under copyright. And the other thing is the integrity. That, for example, the work of an author, you make changes without, the authorship is still there. Mr. A is still the author, and then by you, the content, you make changes. For example, Mr. A says that, uh, 2 is, okay, the 2 equals to X, for example. And I said that, Mr. A says that in his or her book, in his book, 3 equal to X. That is, not maintaining the integrity of the work. I'm just giving you a simple example. Okay. For example, like, some filmmakers, when their works are reproduced in color form, they object to that because they want their work to be in black and white. When it is reproduced in color form, they object to that because they said that integrity of the work, which is meant to be black and white, is compromised. So these are the things that comes under moral rights, which is basically unalienable. Now, we have a long lecture, quite a pretty long lecture. And then in the process, we have discussed the bond between the author and the work and what is authorship. Then we also mentioned copyright can be applied to creative works, and then in what is intangible work and whether fixation is necessary or not. That also we have discussed. And then we also discussed neighboring rights, and then the exclusive rights which is given to copyright holders, which is also called bundle of rights. We have mentioned that. Then we also said that copyright is actually a national law which is taken, the framework is taken from various international treaty, including the Berne Convention and WIPO Copyright Treaty. Then copyright law includes, we said, a number of limitation and exceptions, both at the national and international level. So with that, we have come to the end of today's class. Thank you very much.